Red is all right. Red is. Honorable Chancellor of the Judiciary Acting, Madam Justice Yonette Cummings Edwards, OR CCH. Honorable Chief Justice Acting, Madam Justice Roxanne George SC CCH. Honorable Attorney General Mr. Mahabir Anil Nandalal. Honorable Judges of the Court of Appeal of Guyana. Honorable Judges of the High Court of the Supreme Court of Guyana. Commissioners of Title, Chief Magistrate Acting, retired judges of the Court of Appeal, retired judges of the High Court, senior counsels, President of the Guyana Bar Association, members of the bar, and the relatives of the late Honorable Justice Stanley Alfred Moore, SC, and the late Mr. Rex Herbert McKay, OR CCH, SC, special invitees all. Good morning and welcome to this special sitting of the full bench of the Supreme Court of Judicature. To pay tribute to the memory of the late Honorable Justice Stanley Alfred Moore, SC, and the late Mr. Rex Herbert McKay, OR CCH, SC. This morning, I will take you through the order of speeches for this special full bench sitting of the court. The Honorable Attorney General, Mr. Mahabir Anil Nandalal, Senior Counsel, will be our first speaker. He will be followed by Attorney at Law, Mrs. Abiola Wong Innis. Then the President of the Guyana Bar Association, Mr. Kamal Ramkaran, will follow her. They will be followed by Mr. Neil Boston, Senior Counsel. And the Honorable Madam Chancellor, Justice Yonette Cummings Edwards, and Madam Chief Justice Roxanne George will bring our proceedings to a close in terms of speeches. I now invite the Honorable Attorney General, Mr. Mahabir Anil Nandalal, Senior Counsel, to make his presentation. Thank you.
Honorable Chancellor of the Judiciary, Honorable Chief Justice, Honorable Justices of Appeal, Honorable Judges of the High Court, former Speaker of the National Assembly, the distinguished Ombudsman, members of the Inner Bar, President of the Guyana Bar Association, relatives of the deceased, ladies and gentlemen, may it please your honors, the privilege is mine to offer my tribute. Firstly, to Mr. Justice Stanley Moore of Senior Counsel, and then to Mr. Rex Herbert McKay of Senior Counsel and of the Order of Roraima and the Cacique Crown of Honor. Your honors, Mr. Stanley Moore was born on the 1st of July, 1935 in New Amsterdam, Berbice, to a Surinamese mother, Olivia Isabella Walcott Moore, and Guyanese father, Llewellyn Cornet Moore. The family moved to Kitty, Georgetown, when young Stanley was only 2 years old. His father, a marine engineer, enlisted with troops in World War II, but unfortunately never returned home. His mother, a seamstress, raised him and his brother Carlyle Moore as a single parent with the assistance of relatives of both his mother and father. Stanley Moore attended St. James the Less Anglican School and Tutorial High School, where he was among the first batch of students at Tutorial High to write and pass the Cambridge and London sixth form exams. After completing high school, Justice Moore started as a pupil teacher at his alma mater and then worked as a customs officer for Her Majesty's Customs Department, where I believe his interest in the law was first ignited. I have read that since he could not afford formal legal education, Justice Moore then began studying law on his own and eventually joined a law class with the likes of Desiree Bernard, Duke Pollard, Mohammed Ayub Ali Magdoum, Aubrey Fitzgerald Bishop, and Rex McKay, under whom he started out to practice as his junior, and then with whom he co-founded the law firm of McKay and Moore. Stanley Moore obtained his LLB degree from London University while still working as a manager at Booker's Enterprise. He then enrolled at Lincoln's Inn to study for the English bar examination. In 1970, on completion of his final bar exams, Stanley Moore earned a Commonwealth scholarship to pursue a master's degree at the prestigious University College, London. Justice Moore was called to the Guyanese bar on the 25th of July, 1970, in the year of our Republic. At that time, Justice Moore had to have been among the first lawyers in post-colonial Guyana and perhaps the Caribbean to be qualified with a master's degree in law. Stanley Moore practiced at the civil and criminal bars and, as mentioned before, co-founded the law firm of McKay and Moore, one of the lasting partnerships in our legal profession. In 1973, Justice Moore acted as a magistrate, and in 1979, he served as an acting High Court judge in Guyana. He lectured at the University of Guyana, at that time the one-year LLB program, for several years, and taught several distinguished legal minds, including Chancellor Carl Singh and the late Chief Justice Ian Chang, and dozens of others who have acquitted themselves with distinction in Guyana, the Caribbean, and of course, beyond. This was a period that coincided with the establishment of the University of the West Indies, which offered for the first time a West Indian law degree. In this regard, Stanley Moore made a significant mark in molding an indigenous legal profession in Guyana. I am told that he was an excellent teacher of criminal law, as his students were able to benefit tremendously, no doubt, from his knowledge in the practice at the criminal bar. Not unlike many lawyers, Justice Moore dabbled in politics, serving as a member of parliament from 1981 to 1982, and as Minister of Home Affairs under the Lyndon Fobbs Sampson Burnham administration. His other political appointments included Attorney General of Montserrat in 1990 and acting governor of Montserrat representing Her Majesty the Queen. In 1992, Justice Moore was appointed a Supreme Court judge in the Eastern Caribbean, spending his first stint in Grenada until 1996, and the second in the British Virgin Islands until the year 2000. After that, he served as a judge on the Bahamas Supreme Court. Following his quote-unquote retirement, he was appointed a judge in the Court of Appeal of the Republic of Botswana from 2004 to 2010, and then the Kingdom of Eswatini, formerly Swaziland, from 2010 to 2014. Justice Moore returned to Guyana in 2016 on the urging of his mentor and friend, Rex McKay. At age 85, Stanley Moore decided it was way yet too early to retire and decided to continue practicing law at the civil and criminal bars in Guyana as a partner in the law firm he co-founded with Mr. McKay. The year before he died, still active in practice, he said in an interview, and I quote, "Lawyers don't stop working until our minds stop. I just can't retire and go home. I think it is the way we lawyers are built," unquote. From all indications, Stanley Moore was busy until his passing on the 1st of April, 2023. As a judge, Justice Moore rendered several notable and distinguished judgments, including Gary against the Attorney General of Grenada, 2001, United Kingdom Privy Council, page 30, Daly against Daly, 2003, United Kingdom Privy Council, page 65. This one was from the British Virgin Islands. Of course, Gary was from Grenada. Archer against the Registrar General, 2004, United Kingdom Privy Council, page 31. That one was from the Bahamas. Diedrich Sherland against Talanga Stiftong, 206, United Kingdom PC, 58, from the Bahamas again. Oliver against the Queen, 2007, United Kingdom Privy Council, 9, from the Bahamas again. And Innis versus the Attorney General for Christopher and Nevis, St. Kitts and Nevis, 2008, United Kingdom Privy Council, at page 42. In all 6 cases, the Privy Council upheld the first instance judgment of Justice Moore. And when I was going through the reports of these cases, it was amazing to see the manner, rather the copious references that Her Majesty's Privy Council made of Justice Moore's first instance judgment in order to demonstrate how the Court of Appeal in the respective cases fell into error. But there is one case out of Swaziland that I would like to particularly mention. And it is the case of Swaziland Independent Publishers, Pty Limited, and another against the Queen, 2014 SZSC, page 25. A constitutional law decision delivered by Justice Moore on press freedom when he sat as an appellate court judge in the Supreme Court of Swaziland. While the decision addressed the ever-pervasive issue of freedom of expression, on which the jurisprudence is replete, it is significant because rarely do we get a judgment that adumbrates the responsibilities that come with that right and freedom of the press. At the time, there was no judicial precedent in Swaziland treating with a particular issue. In this matter, 2 men, one a journalist and editor of a monthly magazine in Swaziland, The Nation, and the other, a human rights lawyer, published 2 articles criticizing the judiciary of Swaziland for its lack of impartiality and independence. They condemned the actions of the Chief Justice of the High Court for ordering the arrest of a government vehicle inspector. They were arrested and charged with 2 counts of contempt of court. The defendants argued that the counts were unjustifiable limit to their freedom of expression as guaranteed by the Constitution, and that the arrest warrant was unconstitutional, unlawful, and irregular. They were convicted and sentenced to 2 years imprisonment without the benefit of bail. The case gained international attention from press freedom fighters and Amnesty International. The appeal against the conviction and sentences were allowed in part. Sitting on appeal from that decision, Justice of Appeal Moore made the following seminal observations, and I quote, "The 2 articles in the Nation, which are the subject matter of these appeals, illustrate the ancient principle that all good things must be enjoyed in moderation. No freedom is totally and absolutely free. All freedoms are subject to 2 principal qualifications: the rights of others and the public interest. These 2 articles, written by the same person, illustrate the kind of searching and critical comment which represents the legitimate exercise of the freedom of the press on the one hand, and the kind of article which strays into the impermissible terrain of scandalizing the court." Unquote. So Justice Moore was examining a situation where press freedom at its widest, what the latitudes are, and on the other hand, when it exceeds those boundaries and then enters the treacherous domain of scandalizing the court. Justice of Appeal Moore drew a distinction between acceptable criticism in one of the articles which used such words, and let me go this over again. Justice Moore drew a line between acceptable criticism in one of the articles which used such words as rubbished, criminal, and treasonous in describing particular court decisions, and the unacceptable criticism in the other article which undermines the public confidence in the judiciary. Speaking on the latter, Justice Moore elegantly enunciated as follows, and I quote, "One final observation. Having plunged his contemptuous knife into the hearts of the judiciary to its inglorious hilt, the author, as if infused with the fiendish glee, could not resist the almost sadistic urge to give it one final twist by twice addressing the Chief Justice, whose office lies at the pinnacle of the judiciary of this kingdom, by the title of Your Worship, which is the fitting form of address for judicial officers who are members of what Lord Diplock described as the lower judiciary. The author disdained even to afford the Honorable Acting Chief Justice the courtesy of his proper form of address. The writer's guilt of the offense of scandalizing the court has, on the evidence dripping from his querulous pen, been overwhelmingly established. His conviction by the trial judge cannot, therefore, be faulted. Writing style of this type is either now moribund or forever gone. But that is how Justice Moore expressed his judgment. Justice Moore's graphic and eloquent use of the Queen's English permeated beyond his legal career. He also had a career in radio broadcasting and distinguished himself as a cricket commentator. He also offered his opinion on a wide variety of public interest issues on radio programs such as Viewpoints and Sports View. The younger persons who are here would be unaware of these radio programs. This was long before the advent of television and obviously the internet and the social media to which we are now addicted. Justice Moore served as a member of the Judicial and Legal Services Commission of the Eastern Caribbean Supreme Court from 1999 to 2000, as well as on the Rules and Revision Committee of the ECSC, the same institution, during the same period. He also served in other capacity as an honorary master of the bench at Lincoln's Inn, associate member of the American Bar Association, and as a fellow of the Commonwealth Judicial Institute. Between 1972 and 2000, he lectured not only at the University of Guyana, to which I alluded earlier, but was also a visiting professor at Florida State University and participated in lecture tours to the Republic of South Africa in 2004. Stanley Moore has authored several publications, including Offshore Banking, Friend or Foe, a Commonwealth Secretariat publication, The Right to a Fair Trial and Access to Justice in the Commonwealth Caribbean, an Inter-Rights publication, and a manual for police prosecutors in the Commonwealth Caribbean. He served on several commissions of inquiry and tribunals held in Florida, the Bahamas, Bermuda, Grenada, and Montserrat. Here in Guyana, Moore served as the lone commissioner and chairman of various commissions of inquiry held between 1970 and 1990. More recently, in 2019, Justice Moore was hired by the Ethnic Relations Commission, along with Lloyd Smith and Jairam Pitam, to conduct an investigation into the hiring practices of GCOM, still a very topical issue, on allegations that former acting Deputy Chief Elections Officer Vishnu Prasad was overlooked because of his ethnicity, despite him being the top-ranked candidate. In finding that Vishnu Prasad was indeed the most qualified candidate for the position of DCEO of GCOM, Justice Moore, as chairman of the subcommittee of the ERC, conducted the investigation and presented its report to the ERC. In essence, he found against GCOM, the institution that hired him, demonstrating his independence and the type of fortitude and mettle to his character that permeated his life in and out of the law. In the report, Justice Moore commented on Guyana's multicultural and multi-ethnic society and the need for tolerance in all spheres. His admonitions can be elevated to an aspirational national ethos for which we can all strive as citizens, when he stated as follows, and I quote again, "Every citizen is entitled to be treated fairly and justly in all spheres of national life, but more so in the public sectors. We can all drum together to a unique Guyanese rhythm and sing our national songs together with one voice. That should be the vision for all of us as we strive towards the ethnic fusion that lies at the heart of our national life. Unquote. The year before he died, the Guyana Bar Association honored Justice Moore for his illustrious 50-year career, an honor no doubt well deserved. I was privileged to be present. He spoke, and I sadly observed that age and health were finally taking a toll on his body and mind. He was in a wheelchair, but yet still I recall him having the presence of mind to dedicate a large portion of his speech to what a wonderful, loving, and supportive companion his wife was to him over the decades of their marriage. In paying homage to this legal eagle, I can do no better than adopt the words of Queen's Counsel Harvey Tynes, who during a ceremony to mark Moore's retirement from the Supreme Court of the Bahamas in December 2022, described Justice Moore as a man of great wisdom and said in his tribute, I quote, "The fear is born of the awesome responsibility to do justice to a man who is exalted in thought, expression, and bearing. The deference is born of a desire to do justice to a man of unusual intellectual and moral worth, to a man of nobility and grandeur, to a man who represents the perfect blend of the finest qualities which every judge ought to possess, to a man who over a period of 3 short years, Bahamian lawyers have come to regard as a friend and a brother. I believe I speak for all lawyers in Guyana as titular head of the bar when I say that we have been exceptionally honored by the life, contributions, and legacy of the legal luminary Stanley Moore. On behalf of the legal profession, the government of Guyana, the Attorney General Chambers, and personally, I wish to thank Stanley Moore for his exceptional work to the legal profession of his country and indeed the jurisprudence across the Commonwealth. To his wife and children and relatives, I offer deepest condolences, and a grateful nation thank them for lending us this outstanding son. Might I proceed today? Thank you very much, Your Honor. Upon learning of the death of Rex Herbert McKay of Senior Counsel, the Order of Roraima, and the Cacique Crown of Honor, I wrote the following on my Facebook page, an excerpt only of which I will share. The legal profession mourns the loss of another giant. Rex Herbert McKay, Senior Counsel, ORCCH, died this morning. He was 95 years old. Mr. McKay's distinguished and sterling legal career spanned approximately 6 decades. He was admitted to practice law in British Guyana in the year 1956, long before any one of your honors were born. Most of us were not even a thought. Having completed his legal education at the University of London and Lincoln's Inn, where he graduated as a barrister at law. Almost immediately upon his return to British Guyana, Mr. McKay, through his industry, his ability to do research, and his impeccable style of writing, began to make an impact in the legal profession. These were traits which obviously only improved immeasurably with the passage of time. So much so that nearing the end of his career, Mr. McKay's knowledge of the law was almost encyclopedic. No doubt he was a voracious reader of the law, both in legal stature and learning, both in physical stature, and learning. Mr. McKay was a legal colossus. He used both his imposing physical frame and vast knowledge of the law to his strategic advantage. He acquitted himself with distinction, initially in criminal law and then civil law. When constitutional and public law began to assume prominence in the early 80s and onwards, he loomed large in that area of the law as well. Very few lawyers, not only in Guyana, but the entire Commonwealth, were able to achieve such distinction in all these various and varying branches of the law. Mr. McKay appeared in almost all the leading cases of his time in Guyana, in all the aforesaid areas of the law. The law reports of British Guyana, the Guyana law reports, the West Indian law reports, and the Commonwealth law reports are adorned with the many legal cases in which he appeared, both in Guyana and in the Caribbean. Mr. McKay's legal acumen and industry for research came to the fore very early in his legal career in the landmark case of Peters and Patterson, 1961, LRBG at page 176. At that time, the issue that Mr. McKay as counsel raised were without precedent in this jurisdiction. That is, the difference between attachment and committal proceedings in respect of non-payment of money as ordered to be paid by a high court judge. Those submissions trace the entire historical evolution of attachment and committal proceedings in the United Kingdom, of course, in order to demonstrate their differences, both in principle as well as procedure. Additionally, the submissions underscored the important legal principle that both applications affect the liberty of the subject. Strict compliance with the rules and procedures, therefore, are necessary, and a respondent or defendant, as the case may be, is entitled to take any technical objection with regard to their procedure. The multiple legal principles distilled by Mr. McKay in those submissions, which were liberally quoted by the hearing judge, Justice Bollards, continue to guide lawyers and judges alike up to today and have been continuously referred to in reported cases. For example, see the judgment of Chancellor George in Sukraj against Burnett, 1992, reported in the West Indian Report, where the learned Chancellor himself, a great legal researcher, borrowed generously from the judgment of Bollards G. In the area of criminal law, Mr. McKay appeared for both the defense and the prosecution. He prosecuted some of the most high-profile and politically controversial cases in the 1970s and 80s, including the murder charge filed against Arnold Rampersad in 1974 and the arson charges filed against Dr. Walter Rodney and Dr. Rupert Rupnarain in 1979 in respect of the burning of a building on Camp Street, which housed an office of the People's National Congress. It was during the trial of Rodney and Rupnarain that Jesuit priest Father Bernard Dark, a reporter who was covering the case for the Catholic Standard, was stabbed to death in front of the Ministry of Home Affairs on Brickdam, less than 100 meters from the Georgetown Magistrates Court, where the case is being tried, and the Brickdam Police Station. In the Arnold Rampersad's case, Mr. McKay, as a special prosecutor, achieved a feat never accomplished before or after in the legal history of this country. He succeeded in his application to move a murder trial from the Berbice Assizes to the Demerara Assizes on the ground that the state would not get a fair trial in Berbice because the jury was politically biased against the government of the day. Secondly, it was the first time that an accused person was tried 3 times for the offense of murder before a judge and jury, with Mr. McKay prosecuting on all 3 occasions. Naturally, this case excited international attention and attracted the presence of many lawyers from the Caribbean, including the late Maurice Bishop of Grenada, as well as John Bowden from the United Kingdom. Mr. McKay also distinguished himself as a defense counsel in many leading criminal cases. In the state against Balkaran Singh, 1983, unreported at this stage, and we need to get this case reported. This case is reputed to be the first kick-down-the-door bandit incident in Guyana. Mr. McKay and 2 other legal giants, Dudnot Singh and Bernard de Santos, constituted a defense team. The case addressed several important legal issues in the criminal law, including acting in concert, joint enterprise, admissibility of confession statement, the murder felony rule, and the doctrine of recent possession in larceny. No doubt, Mr. McKay would have contributed significantly in his submissions to the distillation of these complex disparate legal issues. In Martin against the State, 1988, Mr. McKay appeared for the accused who was charged with murder. In this case, the concept of a dying declaration as a res gestae was expansively explored and expatiated by the Court of Appeal of Guyana. Mr. McKay was equally proficient in the areas of civil, constitutional, and public law. It would be impossible for me to do justice to the repertoire of cases in these various areas in which Mr. McKay appeared, having regard to the constraints that I currently operating under. Many of these cases addressed and settled issues of law that are not only novel, but of high constitutional and legal importance. And in each of these cases, Mr. McKay's contribution in the form of submissions would have certainly enriched the jurisprudential value of the written judgments which have emanated therefrom. For example, in Caterpillars of America against the Attorney General, 2062 Estinian report, our Court of Appeal confirmed that the American concept of eminent domain forms part of the jurisprudence of Guyana. In re-application by Aubrey Norton, Chief Justice Desiree Bernard ruled that a decision of the Chief Elections Officer and GCOM is judicially reviewable prior to an elections petition. It is this crucial ruling, along with another case in which Mr. McKay appeared, Joseph Hamilton against the Guyana Elections Commission 2001, that were used during the 2020 general and regional elections to persuade firstly Justice Navindra Singh and secondly Chief Justice Roxanne George to review certain decisions of the returning officer for Region 4 in an application filed by yours truly in the name of Riaz Holadar. It is this singular case which saved the franchise of the electorate at those elections. In Chandra Narayan Dubey against the Attorney General, 2000, Mr. McKay successfully argued before the Guyana Court of Appeal for his client to be granted an equity in land in a Roman Dutch land law system that does not recognize an equitable interest. By this amorphous equity, Mr. Dubey was allowed to remain undisturbed in possession of state lands for 25 years in futuro. In Ray, an application by Carl Hanuman, 1999-65 West Indian Report, page 157, Mr. McKay was able to persuade the court that an important part of natural justice and fairness included a consultative process that requires meaningful participation and an obligation to provide reason for the eventual decision. In Clarence Chu and Hyman against the Attorney General, 2006, 72 West Indian Report, Mr. McKay challenged the constitutionality of the then newly enacted Revenue Authority Act on multiple legal grounds. Although he was unsuccessful both in the High Court and the Court of Appeal, both courts rendered very detailed and reasoned judgments on a number of crucial issues in constitutional and public law. From 1992 until he retired, Mr. McKay appeared in every leading case filed against the government of the day, including elections petitions and cases in relation to elections, including the landmark elections petition case by Esther Pereira. Mr. McKay also appeared in several political cases in Antigua and St. Lucia. He also served as a Justice of Appeal in the Court of Appeal of Grenada that heard a Maurice Bishop assassination case, reported in the West Indian Report as Mitchell against the DPP, 1985, 32 West Indian Report, page 241. In practice, he was a fierce competitor, always extraordinarily prepared and exceptionally tenacious. If there was ever a law authority to support him, the position which he advocates, notwithstanding if it is reported in a most obscure source, he would find it and draw it to the court's attention. Although it was in the latter half of his career, I appeared against him in many cases, particularly in the political cases, as he was always on the opposite side. It was never an easy task. He reduced sledging at the bar table and on the corridors of the court into a fine art and dished it out to opposing counsel with seamless and uncanny ease. Even the bench was not immune. I recall several times he invoked the metaphoric description and assigned it to judges whose decision did not meet his expectation. And the metaphoric reference was to that feathered animal made famous by Harper Lee in that American great novel. Like every counsel who appeared against him, I endured my fair share. Notwithstanding, you knew that you were facing a legal gladiator, and that realization alone propelled excellence. I enjoyed the challenges and learned greatly from them. His aggression to win was another motivating factor. If the ruling is ever against him, rest assured, a notice of appeal will be filed and served in the shortest possible time. His zeal was exceptional and dogged determination inspiring, although sometimes infuriating. No doubt, Rex Robert McKay has etched his name in the annals of our history as one of the greatest lawyers Guyana has produced. Not surprisingly, He was awarded Silk in the mid-70s and was bestowed with 2 national awards, the Cassie Crown of Honor and the Order of Roraima. Most recently, he was fittingly recognized by the Caribbean Court of Justice, Academy of Law, and honored among 48 outstanding Caribbean lawyers and jurists. Mr. McKay was also a sports enthusiast as well as an entrepreneur. He was a national cyclist and a first division cricketer of Maltino's Sports Club. His knowledge of cricket, football, basketball, boxing, horse racing, and other sports discipline was perhaps comparable with his knowledge of the law, and has a lot of knowledge. He was always ready to update you on any ongoing international sporting event or any sports personality. As a businessman, he was engaged in a number of commercial ventures, including an airline and television business, owning and operating the once popular WRHM TV. In conclusion, Herbert McKay, SCORCCH, had nothing short of an illustrious career in the legal profession and would have impacted the lives of hundreds of lawyers over his marathon 60-year span of practice. His contributions will continue to guide lawyers and future generations in many years to come. The void left will certainly take a long time to fill. To his children, grandchildren, and other relatives, on behalf of the government of Guyana, the Attorney General Chambers, and personally, I offer my most profound condolences. Thank you very much, Your Honors.
Thank you, Honorable Attorney General. We will now have Attorney at Law, Mr. Zabiola Wong Innis.
May it please you, Chancellor, Acting, Chief Justice, Acting. Protocols having been duly observed, permit me to proceed in the same order of the Honorable Attorney General. In a collective tribute by the judicial officers, management and staff of the Eastern Caribbean Supreme Court for the Honorable Justice Stanley Alfred Moore, retired, it was noted, and I quote, "He was a Guyanese by birth, but an international man at heart. He had a distinguished legal career in various fields of the legal profession, including his appointments as a magistrate and then on the High Court bench in several Eastern Caribbean states, and subsequently on the Court of Appeal in Botswana and then in the Kingdom of Swaziland, and he later returned to private practice. I had the privilege of meeting the Honorable Justice Stanley Alfred Moore, retired, in August 2016, when he recommenced his private practice in the chamber of McKay and Moore, the law firm that bears his name, and that of Mr. Rex McKay, Senior Counsel. He remained a student of the law, and the last case in the High Court that I'm aware of that he did was in September of 2022 in the criminal assizes. The charge was murder, and his client was acquitted. During the years from 2016 until he stopped practice in the latter part of 2022, he often visited my office for us to engage in discussions on various areas of civil law that he thought was necessary to sound out his views on particular points of the law. I gained more through those encounters, as I observed that even though he was highly knowledgeable on particular points, on the particular points on the discussion, he was still humble enough to engage in these discussions with an open mind. As I reflect on our interactions from the year 2016 until his death, I can unreservedly say that he was humble, wise, and ethical. During those times, I also observed from our conversations the deep fondness that he had for his immediate family, particularly his wife, Cheryl, and his youngest grandson, Donovan, and a few of his lifelong friends from the legal fraternity, particularly the Right Honorable Sir Charles Dennis Byron. A lawyer must always remain humble and a student for life. Those are the words from Shivangi Prasad. And I think this aptly represents who the Honorable Justice Stanley Alfred Moore was and taught us. May his soul continue to rest in perfect peace. Proceed me now, Your Honors, to proceed to the tribute for Mr. McKay, Senior Counsel. Every worthy attribute that expresses distinction in one's legal career would not be misplaced to describe the impact of Mr. McKay's legal career in the legal profession. He was a legal titan and giant among his peers in Guyana and the Caribbean. For his long, dedicated, and outstanding service as a legal practitioner, he was awarded 2 national awards. He also was awarded Silk in the year 1975. Much has been said and will be said today about his contributions to the legal landscape of Guyana. However, I take this opportunity to focus in a more personal way through the lens that I saw him. I was fortunate to have him as an excellent mentor from the beginning of my journey as a starry-eyed attorney at law when he presented my petition to practice law in October of 2020. I appeared with him and on his behalf in both the Court of Appeal and the High Court, while I was attached as an associate with his firm until around the year 2010, when he constructed a new building at the site of his old office, and he offered me the opportunity to open my own chambers while still being associated with his chambers. I saw firsthand that thoroughness was his guiding trait. He was also a diligent reader of the law as well as non-law material. At the beginning of my career, I went into his office almost daily. And when I did, I observed that he was always reading a book, newspapers, or some medical journal or article, while a news channel was showing on the television screen. To me, he was well read about life in general. And when the COVID-19 virus surfaced in around December 2019, with its origins in Wuhan, China, he followed its progression daily thereafter. He constantly photocopied materials about the virus and shared it with us at the office. Sometime in 2020, after the national lockdown, he stopped coming to the office, but we remained in constant contact. My interactions with him in a professional capacity spanned a little over 2 decades, and this afforded me the opportunity to access from a great pool of legal minds, including but not limited to the bonds that were created with Chief Justice Ian Chang, now deceased, also Mr. Fitzpeter, Senior Counsel, and Madam Justice Louise Esther Blenman, currently Chief Justice of Belize. I remain close with both to date. Further, Madam Louise Esther Blenman remains one of my greatest mentors. During those years with Mr. McKay, I was fortunate to share many special milestones with him, such as his presence at my wedding, when he frequently graced the dance floor throughout the night, and his many simple birthday celebrations at the office. He frequently inquired about the well-being of my husband and my son. Further, in May 2017, when I was first appointed as a member of the Public Service Appellate Tribunal, I invited him to attend my swearing-in ceremony at State House along with my dear friend Justice Ramlal, who seated at the bench today. At that time, his mobility was aided by a walking cane, but he still attended. After the swearing in, the then President David Granger told him that he had invited him to State House on many occasions before, but he rarely attended. He further stated that she, referring to myself, must be very special. Mr. McKay's response in such circumstances was his usual non-verbal one. He just smiled. The majority of my adult years were spent with a first-hand opportunity to observe this master at his game. To say that I consider myself fortunate and humbled by the opportunities that he afforded me would be an understatement. I would not be who I am today without his unswerving mentorship and selfless guidance for the past 20 years. Permit me to thank the Honorable Chief Justice Acton for affording me this opportunity to express this tribute by reflecting on the life of a man that defined excellence in his chosen profession. He was generous, kind, respectful, humble, and genuine. Those that we love and lose are always connected to our heartstrings into eternity. To his children and grandchildren, I continue again to express my profound, heartfelt condolences. May his soul continue to rest in peace. Thank you very much, Your Honor.
Thank you, Mr. Zabiola Wong Innis. We will now have the President of the Guyana Bar Association, Mr. Kamal Ramkaran.
Honorable Chancellor, members of the Court of Appeal, Honorable Chief Justice, judges of the High Court of the Supreme Court of Judicature, Honorable Attorney General, Mr. Ombudsman, former Chief Justice of Belize, Mr. Kenneth Benjamin, Judge of the Land Court, members of the Inner Bar, ladies and gentlemen, relatives of Mr. Stanley Moore and Mr. Rex McKay. It is fitting that today's special sitting recognizes together Messrs. McKay and Moore, whose names together adorn the leading set of chambers over many years, even in the absence over much of those years of Mr. Stanley Albert Moore. The name persisted, was prominent in signs and on pleadings, and I always wondered, who was this Stanley Moore, who among all other lawyers, the legendary Rex Herbert McKay, chose to join in partnership in practice? One thing that always resonated in my mind each time I saw that signboard on South Road, Kroll Street, and their name was that Stanley Moore chose, he had an LLM and it was on the sign, that was that Stanley Moore chose to do a master's degree in law at a time when it was very unusual for practicing advocates to go on to further their studies in that way. Without knowing him at all or knowing anything about him, knowing that he did that elevated his status in my mind as a man learned in the law and a man who loved the law each time I saw the sign and the reference to the LLM. When I decided to do one by distance studies just after qualifying as a lawyer, his example was one of my influences. I later learned that he had done his LLB degree by distance studies and was among that cohort of later luminaries who attended classes led by Fred Wills. After securing his degree, although he had a young family and a job and the struggles entailed by having a young family, Mr. Moore's pursuit of the law led him to relocate to London, where he earned his master's degree from the University of London on scholarship and his bar qualifications at Lincoln's Inn, from where he was admitted to the bar in 1970 in England. A few days after his admission in England, in July 1970, Mr. Moore's petition for admission to the Guyana bar was accepted by Justice Gonzalez Sabola after being presented by J.O.F. Haynes, Senior Counsel, and Rex McKay, who would himself become Senior Counsel 5 years later in 1975. Mr. Moore acquitted himself well and also his clients mostly the criminal bar, literally and figuratively, of course, where his mentor, Mr. McKay, reigned supreme. In an interview after his death, Mr. Moore's wife, Cheryl, said that he loved criminal law more than civil law and looked at his practice of it as a version of competitive sports, where no doubt he was compelled to excel to bring victory to his client in what could literally be a fight of life and death or freedom and imprisonment. During this period of practice, he was also a magistrate and an acting high court judge. In 1981, Mr. Moore left the law briefly to become Minister of Home Affairs, where he served for about a year. And some years later, after returning to the bar, Mr. Moore took his legal skills around the world to share them with others. He practiced as Crown Counsel in Montserrat, and he became the Attorney General of Montserrat in 1990. He served as a judge in Grenada and the British Virgin Islands between 1992 and 2001, when he retired from the Supreme Court of the Eastern Caribbean. He later became a judge in the Bahamas and then served in the Courts of Appeal of Botswana and the Kingdom of Swaziland. In 2016, Mr. Moore returned home to Guyana and to Kitty, where he had moved from New Amsterdam at 2 to resume private practice. My first interaction with him came shortly afterwards in early 2017, when the Supreme Court enlisted the assistance of the judges of the Caribbean Court of Justice to run a workshop on the new civil procedure rules, which were to come into force in February 2017. Although he was 81 and had already served with distinction as a judge and a lawyer, Mr. Moore was interested and engaged in the civil procedure reform, and he participated in the workshop, giving examples from his years on the bench in the Eastern Caribbean. His speech then, and always, was precise and clipped, and he spoke in complete paragraphs. His demeanor was very serious and judicial, and even in levity, he never really gave up that quiet, dignified bearing, which I came to learn represented who he was. I became bar president in May that year, and Mr. Moore was one of our enthusiastic supporters. He had heard about the 2017 bar dinner late, at which his former Chief Justice of the Eastern Caribbean and then President of the CCJ was to speak, and he had not been able to secure tickets since they were sold out. We managed to get him one, and showing the measure of the man that he was, I believe that he wrote individually to each member of the council to offer his thanks. He later volunteered to serve on our criminal bar committee and served there with great enthusiasm again, as much enthusiasm as he took up practice at the criminal bar, engaging in his competitive sports again in his mid-80s. And for his distinguished service to the law on his return to Guyana and through his career, he was appointed to the office of senior counsel, I believe, in 2020. Mr. Moore's dedication and commitment to law was shown to me most clearly in an email he sent to the Secretary of the Bar Association early January 2022, a year before he died. He was undergoing treatment overseas and he was confined to bed and rendered incapable of doing serious work, according to his email. He had been retained to represent someone in a rape case at the assizes, and when he explained the situation to the prosecutor, she said that she would give a copy of the deposition to the accused and instruct him to get another lawyer. He said to us that his understanding was that the choice of lawyer is a sacred right of an accused person, and he left it up to the Bar Council to determine whether that was an appropriate matter to raise with the bench at our upcoming bench and bar meeting. So he didn't, the measure of the man was that he didn't say, you should raise this, but the way that he phrased it, that you knew that you should. I offer my deepest condolences on the passing of Mr. Moore and those of the Bar Association of Guyana, to his wife, Cheryl, his daughter, Susan, and other relatives of Mr. Moore. He gave his distinguished service, and we truly appreciate it. And I appreciate personally the fact that I was able to meet him and spend some time with him and speak to him on his return to Guyana. In an interview on television, Mr. Moore described Rex McKay as one of his mentors and said that his mentorship, along with that of others, was the thing he held most dear to him in his practice of the profession. He said that from about 1958 onwards, for more than 50 years, Mr. McKay was one of his great mentors and friends and guides in the legal profession and life. Your Honors have also heard Mrs. Wong Innis, who was moved to tears on remembering Mr. McKay. And Your Honors will hear Mr. Boston, who hopefully will not be moved to tears on his remembrance of Mr. McKay, although he might be. They were very close and I used to see them all the time in deep conversation. Your Honors, Mr. McKay was a general and the courtroom was his battlefield. When I first came into practice in 2002, I had the good fortune to see him employ his barrage of various tactics and strategies, among them the deployment of legal arguments, but not exclusively so. Like a great stage actor, Mr. McKay relied on a number of methods of persuasion to ensure that he would succeed in battle. He could employ mock anger and ferocity when required, and he could throw his opponents off by whispering things about their arguments to his many juniors surrounding him like soldiers among their general, which everyone in court happened to hear. If a judge was going along a path which was not in the best interest of Mr. McKay's client, he could show his contempt very clearly without being contemptuous at all. He would deliver his remarks in a formidable voice and with shining eyes, and he would flick his gown with such contempt before sitting down forcefully that you could swear that he would be locked up. But what would the charges say? That you, Mr. McKay, flicked your gown with contempt and sat down forcefully? No court of appeal would take that seriously. I was so impressed with this technique that I once asked him about it, but he sadly denied that he had ever done anything like that. I even used it against him once in a case, and he so enjoyed being challenged that he never ever passed me straight again. He would half mockingly, half jokingly call me the prince every time he saw me thereafter, in relation to me doing that to him. While he liked to dominate the courtroom, he did not want his opponents to fold up and give in. He loved and enjoyed being challenged. Mr. McKay was admitted to practice in 1958, and as I said earlier, he became senior counsel in 1975. And long before I was born, he was regarded as one of Guyana's leading lawyers, first excelling in criminal law at a time when our judges were developing and applying criminal law principles with a capacity on par with and exceeding the standards expected of a final court of appeal anywhere. Mr. McKay added to and contributed to that jurisprudence through his arguments. Mr. McKay was never, as far as I know, involved in active politics, but throughout his career, he was involved in political cases. At one period of his career, he prosecuted criminal cases against political activists for the government, for the police, and at another period of his career, he brought election cases and constitutional cases against the government. But never, again, as far as I know, were any of these cases conducted with any consideration other than legal considerations. He was a lawyer's lawyer, and his arguments were legal and never political. In cases and politics, my father, Ralph Ramkran, was often on the other side of Mr. McKay. Yet, in or around 1987, when he had a personal case, it was to Mr. McKay that regarded then, at least from conversations I could pick up at 8 in the house, as the best lawyer in the country, that he went. The case was against Guyana Airways, a public corporation, but Mr. McKay did not, despite his ties to the government, have any qualms about taking the case and appealing it when they lost in the High Court. I understand from anecdotes that he utilized all of the strategies in his arsenal and succeeded at the Court of Appeal. Mr. McKay had a certain inexplicable power of persuasion over judges. It came from a combination of his preparation. He knew every word in the record of appeal, his erudition. He read law late into the night for enjoyment and loved talking about developments in the law, and his personal qualities as an advocate. Mr. McKay's aging and then his passing have left a huge void at the top of the profession. Although Mr. Lacoop, senior counsel, and Mr. Stobie, senior counsel, a little bit less skillful in invective and sledging, but they are now taking over the leadership of the bar left by Mr. McKay. Your Honors, I offer my deepest condolences and those of the Bar Association of Guyana to the relatives and friends of Mr. McKay, including his daughter Bettina and grandson Brendan, both of whom are lawyers. Thank you, Your Honors.
Thank you, Mr. Kamal Ramkaran. We will now have Mr. Neil Boston, Senior Counsel.
Chancellor, acting, Honorable Chief Justice, Justice of Appeal, Justice at first instance, and many invited friends here. Ladies and gentlemen, it's a privilege today to pay a tribute to a man who I admired tremendously. He was not only my mentor, but he was also my friend. The late Rex Herbert McKay, known in the profession as Tiger, was one of the greatest legal eagles that canvassed in the Guyana courts. Chief Justice Louise Blenman of the Belize Supreme Court, in her article published in the CCJ Academy for Law's Eminent Caribbean Jurist Services, published in January 2024, describe him as a living legend, legal luminary, a lawyer's lawyer, legal titan, brilliant, trailblazer, eminent senior counsel. Those are some of the words and epithets that were used to describe that great legal eagle. Those of us who knew him and researched the contributions he made to the jurisprudence in Guyana and the Caribbean will not blink an eye to concur with the language used by Chief Justice Blenman. Mr. McKay came from humble beginnings. Born in the year 1928 in Alboystown and grew up there. His mother came to Guyana as an indentured servant from Bangladesh. At that time, Bangladesh was part of India. Mr. McKay told me that his name at birth was Nur Muhammad, but he did not move on to say when he got the name Rex Herbert McKay. By Mr. McKay's commitment, dedication, and hard work, he was admitted into the Honorable Society of Lincoln's Inn and called to the Bar of England and Wales in February 1958. He continued his studies in law and obtained the Bachelor of Laws at the University of London in 1915. Mr. McKay returned to Guyana in the year 1958, ready, willing, and able to toil in the vineyard of justice, and was admitted to practice law in then British Guyana in April 1958. He started his career as junior counsel to the late great J.O.F. Ains, Queen's Counsel, one of the finest legal minds to advocate in the courts of Guyana, and subsequently one of the greatest judges of our Court of Appeal. So from the early years in his career, Mr. McKay nursed from the fountain of legal knowledge and subsequently became a fountain of legal knowledge himself, where several lawyers sought his assistance and his opinions. In the initial years of the practice, his forte was criminal law, and subsequently civil law was added to his forte, as well as constitutional and administrative law. Mr. McKay was a great cross-examiner, fearless, aggressive, and yet respectful. He possessed a great analytical mind. He told me that his aggressive conduct offended several judges, many of them threatened to lock him up for contempt of court. However, some of the registrar to those judges used to go across to his office quietly and inform him of what they planned to do. 3 judges he identified were the late Justice Akbar Khan, Harold Bowlers, who became Chief Justice, and Justice Jackson. At one time, he was informed by Justice Akbar Khan's registrar, Mr. McKay, when you appear before Judge Khan tomorrow, don't disagree with him, because he asked me to have an arrest warrant out and prepare same. He said he wants to put that upstart McKay in prison the next day, as he was confident McKay will step out of line, but that never occurred. Mr. McKay also said to me, as a junior to J.O.F. Haynes, there were many cases that he was involved in as J.O.F. Haynes Jr. However, because of the dislike for him by many lawyers, when the cases were reported in the West Indian or Guyana Law Report, his name was deliberately omitted, and only J.O.F. Haynes' name was stated as appearing for the party. An example of such a situation was the case of R.V. Gomes, which was reported in 5 West Indian report. In that case, he made submission before Bowlers J, as well as J.O.F. Haynes made submissions before Bowlers J. And when the matter was reported, only J.O.F. Haynes' name appeared in the West Indian report. I'm happy to be his junior for many years, and I've learned a lot from him. He possessed an ability to work for long hours. The law was his life. He was a hard taskmaster. Whenever I was given a task to do, even though we discussed the issues, when he's presented with the documents after he reviewed same, he will amend same and add new matters. Senior Eddie Lockwood on my left, and I used to refer to him as the headmaster because he always found some issue we did not address. Senior Loku and I and Mr. McKay will sit and discuss the structure of the pleadings or the affidavits. And when the documents were drawn and presented to him, he will write on the documents and suggest more information should be included. Sometimes it is after the third attempt he agreed with the draft. And Senior Loku told me, man, you remember everything. Sometimes it had to be after 5 attempts. Mr. McKay, because of his contribution and the knowledge of the law, he was elevated to senior counsel in the year 1975, which he said Burnham acknowledged his ability and promised that he would have done it before 75. And when he asked Burnham, why I'm not elevated, Burnham told him, I didn't tell you the time, I did promise you it. His contribution to the jurisprudence was immense. One example was the case of State and Gobin and Boniface Griffith that he successfully argued in the Court of Appeal, among many others. That case dealt with whether a caution statement allegedly made by an accused person whose signature is on the caution statement but alleged he did not sign same. The issue is whether a voir dire should be held. It was the view of Mr. McKay that a voir dire should be held, but the other local authorities in Guyana held that there is no need for a voir dire because the accused said the signature is not his. And the leading cases on that issue were State and Danny Ramsing and many others. And McKay was of the view that the Court of Appeal decided Danny Ramsing and others wrongly. When Boniface Griffith and Gobin came on, it went to the Court of Appeal because the judge at first instance did not hold a voir dire. The issue was argued. First, there were 3 judges of the Court of Appeal sat, but there was this tinkling Justice Ballers who felt Danny Ramsing was correctly decided, and Chancellor Haynes has decided, I will assemble the full bench of the Court of Appeal to hear and decide this issue of law once and for all. At the end of the argument, by a majority decision, the Court of Appeal, it was held that the circumstances a voir dire should be held. The lone dissenting voice was Chief Justice Bowlers. And I remember Mr. McKay telling me, Neil, it was fun after the judges descended from the bench at the end of the day. you used to hear curse out between our bowlers and the then Chancellor, not Chancellor, Court of Appeal, Justice Crane. They used to abuse it, or at one time, Chancellor Haynes had to intervene. Because Crane was saying to bowlers, you do not know the law, you don't understand the law. And bowlers were saying the same thing to him. However, that decision of the majority of the Court of Appeal did give rise to a lot of criticism in the Caribbean, more particularly Trinidad and Tobago. When a similar issue arose in Trinidad and Tobago in the case of Ajoda, the Court of Appeal of Trinidad and Tobago criticized the majority decision of the Guyana Court of Appeal when Gobin and Boniface Griffith were cited to the Court of Appeal. Chief Justice Hayatali, who was the president of that court, even got personal with the Guyana judges who were in the majority. He said they don't know what they're about. All the others did was concur with Chancellor Haynes. The only judge, he said, knew the law on the issue was Bowler CJ. When Ajoda was decided by the Trinidad and Tobago Court of Appeal, I was in law school. I remember clearly a Bajan law student in my class said to me, Boston, the Guyana Court of Appeal is messing up the law. But before I left law school, Ajoda went to the Privy Council, and the Privy Council reversed the Trinidad and Tobago Court of Appeal in Ajoda's case and agreed with the Guyana Court of Appeal on the issue. And Lord Bridge even cited extract from the decision of Chancellor Haynes from Gobin and Boniface Griffith. There are many other cases like Uralal and Act 25 West Indian Report, Tulsi Prasad and Andrew James, 72 Guyana, 72 West Indian Report, Control of Custom and Sucraj, 48 West Indian Report, Pereira and the Chief Election Officer. The Learned Attorney General referred to some of these and many of them and highlighted them, so I don't need to rehash them. Mr. McKay displayed a tremendous knowledge of legal principles and cases. His clients can never expect better representation from him, for they were never wrong, and their opponents were always trying to do them an injustice, he will say. He was sought after by many litigants of substance. The law was McKay's life, and he gave the law his all. Even in the advanced years of his life, 80 years plus, he lived for the law. I recall many nights after the hour of 10 p.m., he will call me on the phone and ask me to check cases and report back to him. I must confess that I used to harbor the thought that Mr. McKay was afraid to die. That is why he didn't want to sleep early. He felt he will die in his sleep. I said that because he never likes to talk about death. And whenever I'm driving him, he will say, Neil, don't drive through Cemetery Road, nor the road adjacent to the burial ground. And I will follow his advice. As a legal advocate, he was never fearful of confronting a judge who he thinks was unfair to him. He used to say some judges feel they can talk to lawyers anyhow and raise their voices at lawyers. I remember one day in the Court of Appeal, at that time, I was his junior. I don't remember the name of the matter, but I can recall during the presentation, the late great Chancellor Kenneth George raised his voice at him. When Mr. McKay got up to respond, Mr. McKay raised his voice. Chancellor George said to Mr. McKay, Mr. McKay, do not raise your voice at me. Mr. McKay looked at Chancellor George and retorted, you started, and I responded. Thereafter, no further voice raising did occur at that trial. Another incident occurred at the Commission of Inquiry that was set up by President Hoyt to air evidence and determine whether Justice Barnwell should be removed from office for misbehavior. The chairman of that commission was retired Chancellor Victor Crane, and the two other members were Frederick Rampersad, QC, and Charles Fongafat, retired Court of Appeal judge. McKay posited a proposition of law, and Frederick Rampersad said to McKay, "I am buying that. You have to support same by authorities." As McKay began to cite the authorities to support his legal proposition, Crane intervened time and again and made some remarks. Mr. McKay said to him, "You do not speak to me like that. I am not your son." Crane responded, "I have the power to call the police to put you out of this hearing." Mr. McKay retorted, "Let the police come. I am not afraid. You think you have the right to talk to a lawyer as you like? You nor any judge is possessed of that power." Thereafter, normalcy returned to the hearing without any further animosity. It is interesting to note Justice Crane never acknowledged he had the authority to speak to him the way he did when McKay answered him. McKay's service as a lawyer was not only sought by the government of Guyana, but the government of St. Lucia, Antigua, St. Kitts, Dominica, and other overseas clients of substance. He told me he represented St. Lucia Nurses Association in a dispute with the government of St. Lucia. During the court hearing, he had the privilege of cross-examining John Compton, the then Prime Minister of St. Lucia. And during the course of his cross-examination, John Compton said to him, "Don't ask me that question. You can't ask Burnham such a question in the Guyana court, so don't do it." And the tempered flared. In another matter in St. Kitts, he prosecuted some drug dealers on behalf of the government of St. Kitts. The defendants were represented by St. Kitts' former premier, Lee Moore. McKay made several objections to Lee Moore's line of cross-examination, and Lee Moore was offended by his objection. It was such a terrible scene. Lee Moore invited McKay out to let us fight it outside of the courtroom. "You only objecting, I can't get through with what I want." McKay said it was such a terrible scene that day, even the presiding female judge descended into the arena and said she was ready to fight too. That was the man, Rex McKay. He also sat as an acting judge in the High Court of Guyana, and he presided over the famous case where Attorney-at-Law Janarine Singh Jr. was tried for the offense of manslaughter for killing his neighbor at Orangestein, East Bank, Essequibo, over a land dispute. He made several objections, Janarine Singh was represented by the late, great Lionel Loku, and the prosecution was represented by the late Oscar Parverton. Sir Lionel Loku, in his style, was making a wonderful address to the jury, and he told them that Janarine Singh was attacked by the deceased with a weapon, even though Janarine Singh described the weapon as a knife. Sir Lionel Loku described the weapon as an elongated dagger, and the deceased retreated, and he retreated, and he retreated. And when he could not retreat anymore, he was forced to fire his gun. As Sir Lionel used the word retreat, he will step back, back, back. Parverton did not want to be undone in his address to the jury, And in so doing, he jumped on the bar table to demonstrate how Johnny Ryan attacked the deceased. Judge McKay said to Parvati, please get off the table. This is a trial and not a comic show. McKay also sat as a judge in the Court of Appeal in Grenada after the Bishop government was overthrown and Bishop was executed by Bernard Cour and others. McKay was part of that panel that delivered the celebrated decision of Mitchell, which was sought after in Fiji and the other Caribbean jurisprudence country when they also had a coup. In that capacity, he gave a good account of himself, but he did concur with Chancellor Haynes, who delivered the judgment for the court. He also sat as an arbitrator in several international arbitrations. That one of those arbitration was the green construction against Guy Mine. The other two members of that arbitration were Lord Mustill, who at that time was Lord Justice Mustill, and Lord Stevenson, who at that time was Lord Justice Stevenson. So it tells you that Mr. McKay himself sat in tribunals with some of the finest legal minds from the High Court of London. Mr. McKay was never a socialite. He always expressed distrust for the cocktail circuits. He always says, that is a gossip circuit. I don't want to be there. They talk, they have a drink with you, and then thereafter they talk your name. He was multifaceted. Mr. McKay was a good fast bowler. He bowled opening bowling for Maltino's club. He played in White Cup cricket in Georgetown. He was also a very active cyclist. He participated in several races at Border Ground and other cycling venue in Guyana. Because of his love for cycling, the type of cycles that he rode, and his height, he was known in the cycling fraternity as Saddle Pole. McKay, as a young lawyer, whenever you seek his advice, he was always ready, willing, and able to help. In the process of guiding you, he will always say, the answers to all those issues are in the books. The books are the tools of the trade. Don't forget to consult them. He was extremely a good mentor, and those lawyers who sought his assistance and those who associated with him have learned a lot. His pastime used to be sitting in his office, drinking a couple shots of Johnny Walker Black with coconut water, which I enjoyed on many occasions, or drinking a bottle of Moet champagne, the nectar flavor. Mr. McKay's contribution to the jurisprudence in Guyana was recognized by the government of Guyana, and he was bestowed with the national honors, namely the Cacique Crown of Honor and the Order of Roraima, the second highest national award. Mr. McKay, besides being successful in law, he was also a successful businessman who succeeded in all the business ventures on which he embarked. He was the owner of several fishing trawlers during the time he was involved in fishing business. He once operated a charter airline service between Guyana and the United States of America, known as Guy America. He owned and operated a garment factory in Bel Air Park at the time of his death. He was also a real estate developer and acquired several properties in the city of Georgetown. I once asked him, Tiger, why you pursued business on the side of your legal career? He laughed and he said to me, Neil, very early in my legal career, I discovered there are judges who dislike you for no reason at all. They behave as though they are omnipotent and make life difficult for you. He had experienced that and he decided that he must get involved in business and make money so he can show those judges that he can survive successfully without appearing before them, and said to me, you guys should get involved in business on the side as you develop your career. Mr. McKay was a family man. He was the father of 6 children, 2 of whom are deceased. And one of them is here, Bettina, and they were proud of him, of his achievement. And I am also proud of his achievement because I benefited from him a lot. I will close by adopting the statement of Chief Justice Blenman in her article mentioned above, where she said, his name is etched in the annals of this region's legal history. His legacy will endure through the many lives he touched and impacted, and the cases he championed, and the principles of law for which he advocated. His unwavering dedication to justice reminds us that the pursuit of justice and fairness is an achievable and noble endeavor that transcends and outlasts the lifetime of even the most legendary of practitioners. And with that, I say thank you, judges.
Thank you, Senior Counsel, Mr. Neil Boston. We will now have our Honorable Madam Chief Justice Roxanne George.
Thank you, Madam Registrar. Honorable Chancellor, Madam Justice Janet Cummings Edwards, Honorable Judges of the Court of Appeal and High Court of the Supreme Court of Judicature, Honorable Mr. Mahabir Anil Nandalal, Senior Counsel, Attorney General and Minister of Legal Affairs, Commissioner of Title Esther Sam, Principal Magistrate Magusti, Retired Chief Justice of Belize Kenneth Benjamin, Mr. Winston Patterson, Ombudsman, and Dr. Barton Scotland, former Speaker of the National Assembly, Mr. Neil Boston, Senior Counsel, and other members of the Inner Bar, Mr. Kamal Ramkaran, President of the Bar Association of Guyana, Ms. Abiola Wang Innis, and other members of the Utter Bar, relatives, friends, colleagues, associates of, and staff who work for Mr. Justice Stanley Alfred Moore, SC, and Mr. Rex Herbert McKay, OR CCH SC. Ladies and gentlemen, this morning we celebrate the lives of 2 eminent brothers in the law, whose brotherliness extended to their partnership in the renowned legal chambers of McKay and Moore, which chambers nurtured so many young counsel, and we've heard from Ms. Wang Innis this morning, and provided offices for other more senior lawyers, including Mr. Fitzpeters, SC, Mr. Neil Boston, SC, Ms. Carol Boston, SC, and the late Chief Justice Ian Chang, CCH, SC. As we've heard, Mr. Moore, whose dash of life spanned 87 years from 1935 to 2023, had a career spanning over 52 plus years. Mr. McKay's dash was a bit longer, 95 years from 1928 to 2023, with a career spanning 65 years. While Mr. Moore's career eventually saw him in various judicial positions nationally, regionally, and internationally, Mr. McKay remained primarily a private practitioner throughout, both nationally and regionally. However, Mr. McKay, as we have heard, served briefly as an acting High Court judge here in Guyana and also presided as a Justice of the Peace in Grenada alongside the late, great Justice J.O.F. Haynes, former Chancellor of the Judiciary. The Honorable Attorney General has ably recounted the careers of these learned lawyers, so I won't repeat much of what he has said. My interaction with Mr. Justice Stanley Alfred Moore, SC, was limited mainly because when I entered the profession in 1990, he had already left Guyana and was in the service of the government and people of Montserrat, having previously served the government of Guyana as Minister of Home Affairs from 1981 to 1982. As stated earlier, having been admitted to practice in England and Guyana in 1970, he went on to be called to the bar in Grenada in 1971 and Antigua and Barbuda in 1989. But maybe Justice Moore's most sterling contribution to the legal profession was that as a judicial officer. He served as an acting magistrate and as a High Court judge here in Guyana. He went on to serve as a High Court judge in the Eastern Caribbean Supreme Court from 1992 to 2000, the Bahamas from 2001 to 2002, and lastly as Justice of Appeal in Swaziland, now Eswatini, and in Botswana from 2004 to 2012. Chief Justice retired Dame Janice Pereira of the Eastern Caribbean Supreme Court, in paying tribute to him, said that, quote, while he was Guyanese by birth, he was an international man at heart. And that, end quote, and that throughout, quote, throughout his tenure on the bench, Justice Moore endeavored to do justice, striving not only to help those less fortunate than himself, but also to train those who sought to follow in his footsteps. He set a remarkable example in how he conducted himself on and off the bench, end quote. Notable decisions by Justice Moore have been cited already, but I mentioned Gary and the Attorney General of Grenada, which was upheld by the Privy Council in 2001, as this is a decision that I have applied in relation to the state honoring money judgments. And from a stint in Southern Africa, there are, of course, many cases, but two of them caught my attention. A 2009 civil appeal in Botswana, Minigold and others, and Nyamambi and others regarding the dismissal of a substantial claim for damages for professional negligence, and the Attorney General of Eswatini and Similane and others 2015 on judicial and financial independence of the judiciary. While receiving many accolades, I would want to think that Justice Moore would have derived great satisfaction from the many students he taught at the University of Guyana, University of the West Indies, and Florida State University, and the lives of students he would have impacted while serving on the faculty boards of the universities of Guyana and the West Indies. After, in effect, sojourning in many different lands, Justice Moore returned to Guyana in 2016 and immediately immersed himself in private practice once again. Mrs. Moore is quoted in one of our daily newspapers as saying that Mr. Moore loved the criminal law more than civil proceedings. And indeed, he practiced quite a bit in the assizes on his return and adapted to online appearances during the COVID period. Justice Moore appeared before me once after his return to Guyana. And what struck me is that which stood out for me as a young person listening to his commentary over the radio on cricket and boxing, his command of the English language, his expression, diction, and intonation. At a time when there was no television, he brought the action live and direct, as we would say, with metaphors and similes, painting a vivid picture of what was occurring so that one was left in no doubt about the excitement at the sporting venue. I have been informed by Mr. Edward Lucku, Senior Counsel, and verily believe that he said the following while describing the crowd leaving the Georgetown Cricket Club ground at Border. And I, of course, can't properly represent how Mr. Moore would have said it. But this is what he said, quote, "The crowd wends its way down Regent Road like a giant comedy," end quote. And referring to one of Guyana's leading cricketers, he said, quote, "Proud Bacchus leaps for that one like a Lukanani out of a creek," end quote. The Honorable Attorney General is quoted from a judgment of Justice Moore and his report on the Commission of Inquiry, which emphasized his eloquence of language. I again note that Mrs. Moore has said that he viewed the practices of law as his version of sports. But I would posit that he most likely carried the flair of being a lawyer into his sports commentating. To say the least, Justice Moore even made Rain No King come alive. Ultimately, his contribution to the legal profession of Guyana regionally and internationally was fittingly recognized by the conferment of Silk in 2020 and by the Bar Association of Guyana in 2022. His was a life really well lived, a life of commitment to service, service of people, as he sought to ensure that the rule of law was always upheld, while contributing meaningfully in the field of sports and to the wider society at large. I turn now to pay tribute to the memory of Mr. Rex Herbert McKay, ORCCHSC, who was called to the bar in England and Guyana in 1958. Mr. McKay, who was often simply referred to as Rex, can only be described as a legal luminary who served the profession with distinction. Tall and imposing in stature, he was a larger-than-life figure on the corridors of the court and a formidable advocate. My first interaction with Mr. McKay was as a newly minted state counsel who was sent to observe a treason trial, which was being conducted before the late Chief Justice Rudolph Harper during the October 1990 session. Mr. McKay was the lead prosecutor. To say that that was a learning experience would be an understatement. I would have learned about the admissibility of caution statements at law school, but that case demonstrated how practice met theory regarding how to conduct a voir dire. My takeaways from that case greatly assisted me when I began prosecuting cases in the High Court. My second major encounter with Mr. McKay was as a not-so-new prosecutor appearing before Justice Lennox Perry. It was a one-witness case with issues of interest to serve and identification. I fought hard to get the case to the jury, and Justice Perry initially ruled in favor of the state. However, overnight, judge considered that it would have been dangerous to send the case to the jury on the evidence as it stood. Though thorough and piercing in the conduct of the defense, I was struck by Mr. McKay's pleasant engagements with me as a young counsel on the opposing side. My utter mortification at having to come up against such a legend was dispelled, and he graciously commended me for the manner in which I presented the case for the state. Again, I learned that theory and practice are two different things, that preparation is key. For apart from his formidable memory and vast knowledge of the law, which he used to the advantage of his clients, his notepad demonstrated that he was always prepared. As we return to in-person trials and hearings, it is important that junior counsel come to court to witness and have these experiences, as they greatly assist in one's professional development. Mr. McKay also appeared before me. What a privilege to have had the benefit of a case conducted by a practitioner who is truly learned in the law. Unfortunately, his appearances before me were not many, and I do regret not having been able to benefit much more from his immense learning in the law. Mr. McKay's vast practice encompassed all areas of the law, as we have heard, whether constitutional and administrative law, and civil or criminal law, where he appeared for both the defense and the prosecution. The law reports are adorned with many leading cases in which he appeared. The tributes this morning have done great justice in recounting cases in which Mr. McKay's name has been etched in the annals of legal history. As such, he has made an indelible contribution to the development of the overall jurisprudence of Guyana and the Caribbean. In the interest of time, I would adopt the references made to the cases cited and briefly mention just a few that I have found particularly noteworthy. There's the 1985 appeal of Collymore and Gomes, which dealt with specific performance. And then there was the 1991 appeal of Barnwell and the Attorney General and others, which dealt with the procedure for disciplining of a judge and the right to a fair hearing. In the 1996 case, application by Robert Beresford, the issue determined was that Sir Shararai would like to quash a committal by a magistrate. Shikali and the Attorney General, a civil appeal filed in 2000, addressed the issues of Section 69 of the Police Act regarding ownership of property and the importance of ensuring that an interested party is served with the proceedings that affect them. In the 1998 appeal, the Attorney General of Guyana and Jardine, Mr. McKay successfully argued that the Attorney General, who was not a party to the proceedings of the High Court, could not be allowed to appeal against the decision of the trial judge, in which the Commissioner of Police was named as defendant. The court found the Attorney General was not a proper party and dismissed the appeal. The 2006 case of Committee for the Defense of the Constitution, Inc. and the Attorney General dealt with whether the office of Chancellor and Chief Justice could be performed by the same person. And in the 2004 appeal to CPSA Limited and Andrew James Investments Limited and others that engaged the attention of the CCJ in 2008, the issue was whether the state could have been in adverse possession of land, such as to allow a purchaser to add its possession to that of the state. There are, as we heard, many leading criminal cases in which Mr. McKay appeared, including the State and Fitzpatrick Darrell, 1976, the State and Joseph de France, 1978, the State against Frank Martin, 1987, and the State against Robin Trudeau, 1997. Mr. McKay and Justice Moore appeared together in many cases. I mentioned two. One that was referred to earlier, the State and Goben Griffith, 1976 Court of Appeal, and Shireen Mangu and Sasadai Kumari Prasad, a 2018 CCJ decision. The former is a locus classicus on admissibility of caution statements, while the latter relates to an application for leave to appeal to the CCJ. For his sterling contribution to the legal profession, Mr. McKay was accorded the Honor of Senior Counsel in 1975, as well as national awards of Cassie Crown of Honor and Order of Roraima. And most deservedly, he was celebrated in the CCJ Academy for Law publication entitled Legendary Caribbean Legal Practitioners, where Justice Louise Blenman, now Chief Justice of Belize, described him as a living legend, a lawyer's lawyer, who has left an indelible mark on our region. Mr. McKay will be remembered and will continue to be revered as a man most learned in the law, a shining example of what one can achieve if one is committed to excellence. And apart from his sterling contribution to the legal profession, as we have heard, Mr. McKay was an entrepreneur and in particular was one of the pioneers of television in Guyana. It is pellucid that those who've had the privilege of interacting with these two learned gentlemen are the richer for having had the opportunity to do so. We remember our dear departed seniors as lawyers, incisive, meticulous, and thorough. We would wish that young counsel would follow suit and be just as meticulous in their preparation and presentation of cases, for as we know, this is most helpful to the bench and assists us in the conduct of trials and timely decision-making. We also remember them as multi-talented gentlemen and as devoted family men. They were legal eagles who have soared to be at peace. Even though they have gone to the great beyond, their memories will live on through their contributions to the development of our region, our nation, region, and the world, live on through the legacy of their chambers, through the records of the cases they appeared in or presided over, both reported and unreported. Indeed, given the large number of cases in which these legal giants appeared, it may be a worthwhile project to compile a compendium of their cases. And importantly, their memories will live on through their families, friends, and associates, and the relationships they created and nurtured. To the immediate family and relatives, friends, colleagues, associates, and staff of Mr. Justice Stanley Alfred Moore, more especially Mrs. Cheryl Moore, and his daughter, Attorney at Law Susan Moore, who is my friend, and of Mr. Rex McKay, more especially Ms. Bettina Glassford and Mr. Brendan Glassford, we extend to you our deepest condolences. May they rest in peace. Thank you.
Thank you, Honorable Madam Chief Justice. We will now have the Honorable Chancellor of the Judiciary, Honorable Madam Justice Yonette Cummings Edwards.
Honorable Attorney General and Minister of Legal Affairs, Honorable Chief Justice, Judges of the Court of Appeal and the High Court of the Supreme Court of Judicature, Commissioner of Title, Acting Chief Magistrate, Professor Kenneth Benjamin, retired Chief Justice of Belize, former Speaker of the National Assembly, Ombudsman, President of the Guyana Bar Association, Mr. Ramkaran, Mr. Loku, Mr. Stobie, Boston, Yasin of the Inner Bar, Ms. Abiola Wong, Ms. Sanford Johnson, and other members of the Outer Bar, the widow and children of and other relatives of the late Mr. Stanley Alfred Moore, children and relatives of the late Mr. Rex Herbert McKay, and staff members of the firm of McKay and Moore. Distinguished ladies and gentlemen, good morning. The Grim Reaper has struck, taking two men, nay, two legal icons, two stalwarts of the legal profession and of the firm of McKay and Moore. Longfellow quite rightly noted so many years ago that the lives of great men all remind us that we can make our lives sublime and, departing, leave behind us footprints on the sands of time. These men have left indelible marks, indelible footprints on the sands of time, on the sands in Guyana and the Caribbean. Footprints that perhaps another, sailing over his life's sullen main, a forlorn and shipwrecked brother, seeing, shall take heart again. Today, we are comforted by the immense contribution of Mr. Rex McKay and Mr. Stanley Moore. Even though they're no longer with us, we too can take heart again, having regard to their contribution to the jurisprudence of this country and indeed the Caribbean. Mr. Moore, Senior Counsel, was also an accomplished member of the legal profession who contributed to the jurisprudence of this great land of ours, as well as to the jurisdictions of Antigua and Grenada. Having been called to the bars of those jurisdictions and in England of Lincoln's Inn, he had both executive, legislative, and judicial experience, truly managing a union of the three arms of government. Mr. Moore served as acting governor and attorney general in Montserrat and as Minister of Home Affairs in Guyana. He was also a member of parliament in both Montserrat and Guyana for a number of years. And as a judicial officer, you would have heard that he served as Justice of Appeal in Swaziland and Botswana and in the High Court of Bahamas and British Guyana. He was also part of the Faculty of Legal Education, being a visiting professor and lecturer and member of the Faculty Board and Board of Examiners. Particularly for our purposes, though, we need to highlight the number of cases that, to his credit, and the many trials in which he would have participated successfully in these various jurisdictions. Judgments from Grenada, Bahamas, and Eastern Caribbean, some of them referred to early on by the Attorney General. And in the interest of time, I will just briefly mention some of these. Gary and Attorney General of Grenada, Daly and Daly, Archer and the Registrar General, Oliver and the Queen, and so many other cases stand testimony to the legal expertise and knowledge of Mr. Moore. I have had the benefit of appearing in the criminal assizes as a state counsel before Justice Claudette Singh, with Mr. Moore being defense counsel. And as defense counsel, he was very diligent. He did not miss the beat and objected quite frequently. Even as state counsel, we tried to get our evidence in, even if we were on the right side. And Justice Claudette Singh, being the stern judge that she was, upheld the scales of justice, as it were, to see that justice was served. Mr. Moore also appeared on his return to the shores in Guyana after leaving for other jurisdictions. He appeared as counsel in the Guyana Court of Appeal before us, the presently constituted Court of Appeal, in so many other matters. In one of the instances, Justice Moore was abroad seeking medical attention. And one of these cases would have been called before the Court of Appeal. And to show his dedication to his client, his commitment to his work, and his respect to the court, Mr. Moore appeared virtually from, I believe it would have been Florida, and appeared for his client. Such qualities of dedication, respect, and diligence are to be commended. And we hope that young counsel and even older counsel or seasoned counsel would adopt those qualities. Two of his children have followed in his footsteps, Suzanne and Alex, and we have no doubt that they will seek to emulate their father. There is an Irish poem which tells us that those we love do not go away. They walk beside us every day, unseen, unheard, but always near, still loved, still missed, and very dear. For the relatives of Mr. Moore, we know that Mr. Moore still walks beside you every day. He's still always near, he's still loved, he's still missed, and he's still very dear. The firm in which he operated as a founding member with Mr. McKay of Senior Counsel, the name of that firm is McKay and Moore, in which the practice of the law and the many clients who visited could speak of brilliance, of excellence, of commitment, and of dedication. Those men behind those firms are still loved and are very near to us. Together, they contributed over 100 years of combined legal service to both Guyana and the wider Caribbean, and indeed further afield. I turn now to the contribution of Mr. Rex Herbert McKay of Senior Counsel. It is said that the true measure of a man is the memory he leaves behind. And I would add to that the legacy that he leaves behind. Mr. McKay has left a rich legacy. He has been the recipient of 2 national awards, the Order of Roraima and the Cacique Crown Award honor, for his contribution to the law and long and dedicated service to the legal profession. He has been recognized as an eminent jurist by the Caribbean Court of Justice's Academy of Law. And his legal expertise and acumen have already been expounded by many speakers before me. But prominent among his cases, which I would like to mention briefly, would be the cases of the state against Ram Singh, the state against Balkaran Singh, the state against the France, the state against Gobin and Griffith, the state against Ram Singh, the state against Martin, the Queen and Williams, the state against Darrell. These cases highlight the fact that Mr. McKay had a penchant for the criminal law, and there are other cases to his credit. He had a passion for law and for all things legal. He truly loved the law and read extensively. Concomitantly with his knowledge and his reading would be his contribution to the law, both locally and to the Caribbean. His extensive contribution indeed remain legendary. Mr. McKay served not only in relation to the criminal field, but he also served in and made great strides and contribution in constitutional law, public law, administrative law, family law, where the case of Hiralal and Hack in the family setting remains locus classicus to date. But very early in his profession, in 1967, one of the cases in which he participated, which stands out for me and which indicates his brilliance and his legal acumen, is a case which is called Dubé and Inspector of Police. I know the Attorney General mentioned the case of Patterson and Patterson, but permit me briefly to mention just an excerpt from Dubé and Inspector of that police. In that case, a physician, or one who termed himself a physician, was charged for willfully and falsely using the name of a physician, contrary to the Colonial Medical Services Ordinance. And this case was reported in 1967 in volume 11 of the West Indian Report. The appellant had been found to have a signboard on his premises which stated Dr. J.C. Dubé, MDIH, FSAUI, physician. And among his papers were found 3 sheets of paper on which the above description was repeated together with the words practitioner of medicine. On being charged before a magistrate for a contravention of the Colonial Medical Ordinance and being convicted, on appeal, Mr. McKay appeared for Mr. Dubé. And what seemed like a straightforward case for the state turned out to be a case which, as the judge said, specifically that it must be proved that the appellant acted willfully and falsely, and that the magistrate specifically had addressed his mind to proof of an important element, and such an important proof was missing, which was that the appellant had acted honestly under a genuine belief that he was entitled to describe himself as a physician and whether he had reasonable grounds for that belief. And on that basis, the case was dismissed. Bollard CJ said, "It is a pity in what seems to be a very clear case, there had been a magisterial lapse." And that was the beginning of the expertise of Mr. McKay in so many cases which he successfully won on appeal. I too, like the Chief Justice, recall appearing on the opposite side of Mr. McKay, both as a state prosecutor and particularly in the appellate court, as well as in the full court. And in appearing before Mr. McKay, there was so much that as a young lawyer, one could have learned. But I recall a particular quality of him being very frank and being very fearless, one who spoke out about the excesses of the court, of the state, and if he did not like a decision, he made it known to all and sundry. I recall coming into this very courtroom on the opposite side on a full court matter, a narcotics matter, in which the late Chief Justice Harper presided. And when the decision was rendered, Mr. McKay, the decision was against Mr. McKay. And in that case, Mr. McKay got up, bowed lowly to the bench, but before he bowed, he said, the name of the Chief Justice, the letters CJ has to be renamed. And he renamed it. And he bowed and he left the courtroom with his gongs flowing. I dare not repeat what was the name that Mr. McKay gave to Chief Justice. Mr. McKay, as part of his fearlessness and his contribution to this country, was a member of the Committee for the Defense of the Constitution and was always in pursuit of justice. He was also a philanthropist and generously helped many young counsel and many law students. We know that he served as a Justice of Appeal in Grenada, and we heard today that he served as an additional judge here in Guyana. It all goes back to the human interconnectedness and the fact that all their contribution has made this country's jurisprudence richer. Human connectedness has been borne out in the poem of John Donne when he said, "No man is an island entire of itself. Each is a piece of the continent, a part of the main." And the poet continued that each man's debt diminishes us. And he said, "For I am involved in mankind. Therefore, send not to know for whom the bell tolls. It tolls for thee." Indeed, the debt of Mr. McKay, senior counsel, diminishes the bench and the legal profession as a whole. It is unfortunate that many young lawyers do not attend these sittings to hear of the contribution of legal stalwarts and emulate the notable traits of these legal icons in the legal profession. But we take heart that the senior counsel who were present will continue to make indelible contributions, rich contributions, I see, to the legal profession and assist young counsel coming up so that they too can play a part in this noble profession. On behalf of the judges of the Supreme Court of Judicature, to the sorrowing relatives of Mr. Stanley Moore, senior counsel, particularly his widow, Mrs. Cheryl Moore, his daughter Suzanne, his son Alex, and other dear family members, we extend our condolences to you. We also extend condolences to the relatives, the daughters and other relatives of Mr. Rex Herbert McKay, senior counsel. May their loving souls rest in eternal peace, and may light perpetual continue to shine on them. We will now stand to observe 1 minute of silence as a mark of respect to the lives of Stanley Moore and Rex Herbert McKay. Thank you. You may be seated. Deputy Registrar, you are directed to make today's proceedings a record of the court and tender copies to the relatives of the late Mr. Stanley Alfred Moore and Mr. Rex Herbert McKay, Senior Counsel.